Disclaimer. This material is for entertainment purposes only, and for no other purpose. Please consult a legal professional for proper legal advice, including understanding what this document means. Please consult the actual legal document for all legal uses. This presentation is no substitute for the actual filed document. We cannot help you if you do not follow this simple, reasonable, and good advice. Please let us know about any errors in this presentation so that we can correct them. Unfortunately, we cannot and will not correct any errors made in the underlying documents, so please make sure the error is a presentation error. Thank you very much for your time, support, and interest. We hope you enjoy this content. Sponsors. Unfortunately, there are no video sponsors or channel sponsors at this time. If you would like to sponsor us, please reach out. All donations are welcome. Thank you. Please remember to like this video, subscribe to our channel for more videos like this, and share this video with others. Doing this will help us reach other interested people, and will help to support this channel. We appreciate your action. Thank you. Slip Opinion. October Term, 2021. Note: where it is feasible, a syllabus, headnote, will be released, as is being done in connection with this case, at the time the opinion is issued. The syllabus constitutes no part of the opinion of the court but has been prepared by the reporter of decisions for the convenience of the reader. See United States v. Detroit Timber and Lumber Company, 200 U.S. 321, 337. Supreme Court of the United States. Syllabus. American Hospital Association et al. Versus Becerra, Secretary of Health and Human Services, et al. Certiorari to the United States Court of Appeals for the District of Columbia Circuit. Number 20-1114. Argued November 30, 2021. Decided June 15, 2022. The Medicare statute lays out a formula that the Department of Health and Human Services must employ annually to set reimbursement rates for certain outpatient prescription drugs provided by hospitals to Medicare patients. 42 U.S.C. Section 1395 liters T14A3. That formula affords HHS two options. Option 1 applies if HHS has conducted a survey of hospitals' acquisition costs for each covered outpatient drug. Under this option, the agency may set reimbursement rates based on the hospital's average acquisition cost for each drug, and may vary the reimbursement rates by hospital group. Section 1395 liters T14A3-1. Set a survey, Option 2 applies, and HHS must set reimbursement rates based on the average price charged by manufacturers for the drug as calculated and adjusted by the Secretary. Section 1395 liters T14A3-2. Option 2 does not authorize HHS to vary reimbursement rates for different hospital groups. From the time these provisions took effect in 2006 until 2018, HHS did not conduct surveys of hospitals' acquisition costs, relied on Option 2, set the reimbursement rates at about 106%, and did not vary those rates by hospital group. For 2018, HHS again did not conduct a survey. But this time it issued a final rule establishing separate reimbursement rates for hospitals that serve low-income or rural populations through the 340B program and all other hospitals. For 2019, HHS set reimbursement rates the same way. The American Hospital Association and other interested parties challenged the 2018 and 2019 reimbursement rates in federal court. In response, HHS first contended that various statutory provisions precluded judicial review of those rates. The agency also argued that it could vary the reimbursement rates by hospital group under its Option 2 authority to adjust the price-based reimbursement rates. The district court rejected HHS's argument that the statute precluded judicial review, concluded that HHS had acted outside its statutory authority, and remanded the case to HHS to consider an appropriate remedy. The D.C. Circuit, however, reversed. The court ruled that the statute did not preclude judicial review, and upheld HHS's reduced reimbursement rates for 340B hospitals. Held. 1. The statute does not preclude judicial review of HHS's reimbursement rates. Judicial review of final agency action is traditionally available unless a statute's language or structure precludes it. Mock Mining, LLC v. EEOC, 575 U.S. 480, 486, and this court has long recognized a strong presumption in its favor. Weyerhaeuser Company v. United States Fish and Wildlife Services, 586 U.S. __. Here, no provision in the Medicare statute precludes judicial review of the 2018 and 2019 reimbursement rates. HHS cites two nearby provisions that preclude review of the general payment methodology that HHS employs to set rates for other Medicare outpatient services. See Sections 1395 liters T12A, and Sections 1395 liters T12C. But HHS sets rates for outpatient prescription drugs using a different payment methodology. HHS also argues that other statutory requirements would make allowing judicial review of the 2018 and 2019 reimbursement rates impractical. Regardless, such arguments cannot override the text of the statute and the traditional presumption in favor of judicial review of administrative action. Pages 7 to 9. 2. Absent a survey of hospitals' acquisition costs, HHS may not vary the reimbursement rates only for 340B hospitals. HHS's 2018 and 2019 reimbursement rates for 340B hospitals were therefore unlawful. The text and structure of the statute make this a straightforward case. Because HHS did not conduct a survey of hospitals' acquisition costs, HHS acted unlawfully by reducing the reimbursement rates for 340B hospitals. HHS maintains that even when it does not conduct a survey, the agency still may adjust the average price as necessary. Section 1395 liters T14 at 3.2. But HHS's power to increase or decrease the price is distinct from its power to set different rates for different groups of hospitals. Moreover, HHS's interpretation would make little sense given the statute's overall structure. Under HHS's interpretation, the agency would never need to conduct a survey of acquisition costs if it could proceed under Option 2 and then do everything under Option 2 that it could do under Option 1. That not only would render irrelevant the survey prerequisite for varying reimbursement rates by hospital group, but also would render largely irrelevant the provision of the statute that precisely details the requirements for surveys of hospitals' acquisition costs. See Section 1395 liters T14D. Finally, HHS's argument that Congress could not have intended for the agency to overpay 340B hospitals for prescription drugs ignores the fact that Congress, when enacting the statute, was well aware that 340B hospitals paid less for covered prescription drugs. It may be that the reimbursement payments were intended to offset the considerable costs of providing healthcare to the uninsured and underinsured in low-income and rural communities. Regardless, this court is not the forum to resolve that policy debate. Pages 9 to 14. 967 F. 3rd 818, reversed and remanded. Justice Kavanaugh delivered the opinion for a unanimous court. Thank you for your time. Please remember to like this video, subscribe to our channel for more videos like this, and share this video with others.